शुभ आशीष मांगे, गावे सब जय गाथा। जन जन मंगल दायक जय हे भारत भाग्य विधाता। जय हे, जय हे, जय हे, जय 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 हे।
Thank you all. We'd like to welcome our guest speaker, Rtn Apurva Agarwal from the Nariman Point Club. He is also a member of the RMB. After graduating from National Law School of India University, Bangalore in 1999, Apurva worked with Shah Desai, Doijot and Bhattarapikar. He pursued his LLM at Bond University, Australia, where he achieved academic distinction when his name appeared on the Dean's list. On completion of his LLM, he returned to India, where he worked for DSK and Luthra law offices. He is the founding partner of his firm Universal Legal. Universal Legal is a service law firm. His expertise includes real estate, corporate, commercial, medical, intellectual property, media, and his articles have been published in various newspapers and magazines. Apur, a very warm welcome to our club. Just give me a second, I'll just open your deck.
Okay. What I'm actually speaking about life after death, or how you pass on your assets from one generation to next generation without much of ado and legal hassles and with minimal tax implications. We all have, over a period of time, accumulated a lot of assets, but when it comes to estate planning or succession planning, there's always that saying, abhi time hai na. Why wait? We can wait, abhi time hai. And the question we've seen in the last few years, time nahi hai boss. So you have to start planning your estate planning as of date. Basically, what is estate planning? It is to decide what happens to one's property after your demise. And how it can benefit one heirs and beneficiaries without any legal hassles. See, a common perception estate planning is just that we make a will and it's good to go. It's just not writing a will. There are lots of other implications of just writing a will. It's a process of anticipating and arranging for the disposal of estate, especially if you guys are business houses or having kids studying or working abroad or having a disabled kid. So there are lots of factors you need to take into consideration before planning your estate. What is the estate? It includes every damn thing. Okay, it's not only your property. It includes your bank balances, insurance policies, art, artifacts, mutual funds, shares, name it. Even the bottled water if you own it, your watches, everything. So everything is considered as estate. There are about 5 or 6 myths which I keep hearing about estate planning, and I'll just go through them one by one. Estate planning is meant only for the wealthy, because everybody has some ownership. So you have to plan for how you transfer that asset, whether it's worth 50,000 or probably a few hundreds of crores.
Slowly.
Okay.
You're going very fast.
It does not really matter how much you own in the accounts, it's what you own and how you transfer it from one generation to next generation. That's what the myth number one, It's only for the wealthy people, it's not only for the wealthy people, it's even for a common and middle class and lower middle class people, like a lot of people. Myth number two, estate planning should be thought of only after retirement. अब रिटायर होके 65 साल हो गए, अब estate planning करो. But over the last few years, we've all seen in the media reporting deaths happening in age of 35 to 40, 45. As recently, all media personalities who are as fit as a fiddle are popping heart attack age of 40 to 43.
Don't look at me.
Okay. I mean,
a lot of us are getting a heart attack these days.
Okay, a lot of us are getting it. So, the misnomer कि retirement तक wait करते हैं, retirement के बाद करेंगे, ये सब सोचेंगे. Please remove that myth. You should start planning it right now. Myth number 3. My legal heirs will handle maturity. That is the biggest myth I keep hearing. मेरे एक बेटा वो संभाल देगा, मेरे दो बेटे भाई जैसे हैं, कुछ करेगा नहीं, they look after my wife, my mother, everybody. Boss, over last 22 years of practice, I've seen mother-son fight, I've seen two sons fight, I've seen siblings fight. And I can watch for it. You would have seen it in the extended family or in various corporate houses, extended media. Classic example, the Birla Group, the Reliance Group, and there are various other groups which I don't want to get into it, but classic examples, after the death of the matriarch, people have fought tooth and nail for every ounce of flesh. So please don't expect your legal heirs to handle anything maturely. If you do so, God bless you. And fourth, I have rested my nominees. They will anyways be the beneficiaries of my assets. Please let me remind you, sirs, beneficiary, a nominee is not the heir to your properties. They're just a trustee to the property after your demise until the rightful legal heir is found. So even if your bank account has a nominee, or even if a society where you own the flat has a nominee, they're not your legal heirs. It's just for matter of convenience for the bank and the society to hand over the property to them so that they can wash their hands off the property. That is it. They're not the nominee, they're not the legal heirs. So please remove that myth. Myth number 5, I don't need to seek a legal opinion. Guys, or they're experts, and like you need a doctor when you fall sick, you need a good lawyer to advise you on how to estate and tax plan your estates for future generation. I'll give you one classic example. I mean, probably most of you would know, but maybe ignore it or forget. If your kid or kids are studying in the US, right, and are planning to stay back and work in the US and not come back, right, if they inherit any of your properties, they're liable to pay about 30 to 40% inheritance tax in the US. Okay, because inheritance tax is on worldwide inheritance in the US, not only the properties inherited in the US. That's just one example. So you may have an asset worth 50 crores in India, but you may not have 20 or 30 crores lying in a bank account to pay the US government to claim your asset. So all these are factors which we as lawyers need, advise you on and how to save on that. There are ways and means of saving it. But if you don't go to the expert, obviously all that money will go to the wrong people and wrong thing. Another example, I don't know how many of you guys are Muslims in this room out here. Okay, then I will not take the example, but so let's go to the next one.
You can get an example if you want.
Okay. A Muslim cannot will away more than 1/3 of the property. The rest of the property has to go by interstate succession planning. So we had a lady, and a very prominent name in the Indian classical music world, who was setting assets worth 100 crores plus, married to a Hindu. So somebody made the will thinking she's a Hindu. It came to my office for a second opinion review, and when I advised them that this is a wrong will for XYZ reasons, we had to redesign everything, restructure so that the will could be bypassed and the estate could go to the rightful beneficiary and not go by the interstate succession.
The rightful heir could get it.
The heir who you want to give it to, right? Probably you may not be interested in giving to both your kids or all your kids. You may be interested in giving to one of them, for whatever reason. So why? Under Muslim law you can't do that. Under Hindu law you can't do that. So each one is a personal. So therefore, if you've been reading the media reports lately, there's a move to get a uniform civil code in practice. If that comes through, you really need to start with tax planning in advance. Tax and estate planning, sorry.
Can I ask a question
Yeah,
now?
please.
Okay.
Please feel free to ask questions at any time so that we can answer that problem.
Can you please repeat that part if a non-resident or a US citizen inherits something from here?
Okay. See, any person residing in US and working in US, either as a US citizen or a green card holder or on a long-term P1 visa, have to pay taxes to the US government. And that is on worldwide income. Okay? That's number one. Number two, if they inherit above a certain amount, and each state has a separate amount, so I'm not getting the macro level thing. Worldwide, there is an inheritance tax which they have to pay to the government, US government, which ranges from 30 to 45% depending on which state of US you are staying in.
That is after he sells the house or only if he inherits it?
Only when he inherits the house, not when he sells the house.
Oh.
So today, if you have a house worth, let's say 50 crores in India, hypothetically speaking, and he inherits that house worth 50 crores, the moment he inherits it, let's assume 30% is the inheritance tax. That means 1/3 of 50 crores, roughly of 16 crores or 17 crores, he has to pay the government of US at that point in time. The time he's inheriting, not the time of selling. At the time of selling is a capital gain
So
tax.
property India and give it tax to US.
Yes. It's not a worldwide inheritance. That's what I'm saying, worldwide. I'm not saying within the country of US.
But suppose they don't repatriate, then we keep the money here only.
Do that and the US government comes to know about it. US government has lots of ways and means to do what they want to do. So let's not get into that debate. It will consider financial fraud and be behind the bars for 20 years.
Is that only for US or any other country also?
As far as I know, it's in US and some parts of Europe, which I can have a discussion about later. But US is definitely.
For example, Singapore?
Singapore, I'm not aware of it.
Singapore has no inheritance tax. Inheritance tax is there in UK.
UK
It's
has.
called estate duty.
Yeah.
Okay.
Like in India also we had estate duty till 1985.
Right.
In 85 it was removed.
There was a state duty and wealth tax which got removed.
Question.
Yeah.
If I'm an American
Question.
green,
Yes.
well, up to you. If I'm an American green card holder living in India and I just go back to the US for like those minimum 30-40 days and a year to keep my green card valid, even then I have to pay inheritance
Then
tax.
बहुत अमेरिका जाना जाओ
So, I mean, very honestly, lots of people come to me for advice whether they should immigrate to the US or not. I say, boss, it looks rosy, but look at the tax implications before you decide. Because of paying, forget the inheritance tax, you're also paying income tax on worldwide income. So whether you're earning in India, Singapore, Canada, wherever, you're still paying tax to the US government. Okay. I mean, I'm not a tax expert, but that's the law as of right now. Yeah.
There's been a rumor since a long time of inheritance tax coming into India. Okay. So what is the way out? Assume it comes in some point of time.
That's
Yeah.
part of it.
In India, I'm not talking about all
And I
this.
can watch for it. If our current Prime Minister wins 2024, by 26 it will be there.
Yeah, sure. There is expected any time. So what is the way out?
I'll be discussing that.
Okay, fine.
What about forming a family trust where you put all the properties?
That's part of my discussion. This is such a myth. I'll get to the exact planning of it.
I have one more question. Anyone else with a question?
No more.
Okay. If a Muslim and a Hindu marry, they usually marry as per the Special Marriages Act. Now, if they own 50% of their entire property, even then the Muslim husband can get only 1/3 of the share to.
So that's the need why PCC to come to form. Or the next, when I'm talking about the trust structure. Okay, I think I've already gone through this, but I'll just roughly go through it. You need to plan your stay because of uncertainties of life. You can pop it, forget death. There's another thing you should remember: medical incapacity. You may have money in the bank balance, but if you're in coma or met with a major accident, you can't sign a check. How are you going to draw money and fund your medical illness? So that's part of the estate planning I'm going to talk to you about. When to plan, as I keep saying, now is the best time to plan. Don't think of retirement time. No, back in call, I've known a client of mine, 58, 60 years during COVID time. For the last 5 years we've been advising him. He's, third generation is also got his business. Sir, please start your estate planning. हाँ अभी time है करके during the COVID time he popped him. He has 1 son, 2 daughters, 3 grandchildren. Big infighting happening within the family as of right now. And they're very big in the textile industry. Okay. Now what are the factors we should need to consider for estate planning? One, obviously the size of the sets, how big are your sets? asset holding pattern, because sometimes assets are held in the name of different family members for different reasons. Jurisdiction in which assets are held. Why is that important? Because sometimes you invest in monies abroad and hold assets in Singapore, US, and everywhere, then the income tax issue will come up. Citizenship and residence state of owner assets or beneficiaries. I've already discussed this at length. Like if your kids or you are US citizen, then what happens? Legal framework, remember, each religion has a different legal framework. So lucky, okay, fortunately most of us are Hindus here, so I'm only concentrating the Hindu dynamics. I won't talk about the religion. You can, as a Hindu, I'll just take a diversion, you can will away all your property to any Tom, Dick and Harry, including me or him or anybody, excluding your family members. So we are ready to accept all will gifts. Okay. But honestly,
You're ready to accept
okay.
But you are
So
not Tom, Dick
you
and
as a Hindu can will it to any Tom, Dick and Harry. There's no compulsion that under Muslim law you can only will 1/3 of a property to anybody. The rest has to go by interstate succession. Christian and Parsis also can will it to anybody. Sikhs and everybody, Sikhs and Jains are considered Hindus for the personal law. So keep that in mind.
James?
Hindu,
James?
Hindu.
Sikhs and Jains are considered as Hindus.
Hindu.
I just wanted to ask, suppose if I will away everything to Tom, Dick and Harry,
Right.
okay,
My
so
name is Harry.
can the other people create any problems
Can.
for Tom, Dick and Harry?
Yes.
If the will is registered,
If the will is registered, okay.
yeah.
I'll just come to that. I'll tell you the. Let's just go to the next slide.
My name is Harry.
How do we do the estate planning? The 4 ways: nomination, but nomination is said is only the thing, not the legal trustee. So we align the nomination with the will or the trust what we want to do, so that the person or beneficiary is also the nominee, so it becomes easier. Writing a will, forming a trust. This is something which our firm advises mostly on over a will as a benefit of estate planning and making gifts. Right. I think I've discussed. I've already discussed this. I'm skipping this slide, nomination. Next slide. Okay. Now let's come to will. As I said, a Hindu can will away all his or her property. A will has to have 2 witnesses and 1 doctor's certificate certifying that on the date of signing, the person was of medically sound person. Okay? They have to have an executor who will get the will probated after the person's demise and hand over the property to legal heirs. That process of getting the will probated takes about 8 months to 1 year. Okay, so you are wasting 8 months to 1 year after the demise to get things in order. Secondly, when somebody applies for the probate of the will can be challenged again by any Tom, Dick and Harry, irrespective of whether he has a claim or not. Whether he will succeed or not is a different issue. But our Indian judicial system is so effective, it will take you at least 8 to 10 years before we get to the net result. So for that 8 to 10 years, your properties in your bank account are chock-a blocks lying idle.
Beg to differ. Probates don't take so much time.
Probate doesn't take time, it takes 8 months to 1 year.
8
But
months
if
luggage.
somebody challenges it, then it takes time. Okay. So if there's no challenge, I agree with you, 8 to 12 months, we get the probate done. The only worry is when there is a challenge to the probate or challenge to the will. That will take you at least 7 to 10 years, if not more.
So the challenge he does in the court, no?
Yeah,
When the probate is being
Yeah. See, all the wills in Bombay, wills made in Bombay, have to be probated in the High Court of Bombay. It's a process which takes about 8 months to 12 months or slightly longer, but roughly 8 months to 12 months. So for that, you can use the property, but ownership doesn't pass on to legal heirs.
So is a probate compulsory?
It is compulsory.
So in respect of all assets like bank, shares,
Yes, it's in respect of the will. So will mention all the assets.
okay,
Probate is mainly in case of properties.
properties, right?
Everything, immovable and immovable properties.
Okay, so even
Including
like
a shared demat account, Therefore, if you see the definition of asset which I said, it includes your art, artifacts, shares, mutual fund, insurance policies, watches, anything what you want,
Right.
including this water bottle if you want it.
So you have to go through a probate.
Yes.
You can't just,
No.
if the will is there, your name is there and
You have to go through probate because the probate will testify that the will was validly executed, now it can transfer property. If you haven't made a will, and there are lots of times because चलता है attitude time है समय है मैं will अभी नहीं बनाऊंगा या I not make a trust or whatever I not use state plan, then you have to apply to the High Court for what you call a succession certificate.
right.
And as per the Hindu Succession Act, then the property gets divided among the legal heirs.
So even if the will was registered, you have to probate it.
Yes, all wills have to be probated.
But we'll start, there were four, I think Pankaj, you had the first question.
Yeah, I think you just answered it, that not only property but everything needs to be property.
Everything. So therefore, when we make a will as a firm, we list out all the properties, including immovable and movable properties, and who it has to go specifically.
Coming to the gift part of it, can you give anything, including the money,
Yes,
properties or anything can be gifted?
gift is during your lifetime. I'll come to that later. Will is post to demise.
My point is that if during the period of the probate, if anybody can object or raise an objection to it, why are we making a will?
Because then you can transfer the property to a person who
Anybody
you
can
want to
object to the damn
transfer.
thing.
Right?
But anybody can object to the damn thing.
Yes, anybody can object. So the other ways of planning your estate are only, will is not the only way of doing it.
But I mean, you said it correctly.
Sorry,
I mean,
the Succession Act where it is just recently introduced for a few years that the girls are also entitled to stake claim. The married girls.
Let me answer that question. Under the Hindu Succession Act,
Yeah. Despite of the fact of having probate and everything.
1 second. Under the Hindu Succession Act, and I'm going to talk about Hindu law right now because fortunately everybody in the room are Hindus, not for any other reasons. If you die intestate, that means not leaving a will behind. Your spouse and all your children will get the share of the property equally. Whether you have a daughter, son, spouse, married, unmarried, irrespective, everyone will get the shares equally. So if you got your wife, one son, one daughter, 1/3 each.
Similar, I'll tell you, there was a live example where the daughter has taken equal claim after the probate. Equal claim, it was not mentioned in probate anywhere. And it was testified. Despite that, it was claimed and she was entitled to it.
I'll have to review, see the case, facts of the case, I can't comment on that. But if a will is made, it has to go by the will.
As what has happened is because this is a live example somewhere which I know very personally.
Sir, I would need to see the
and
facts of the
that
case.
solicitors had to agree.
I would need to see the facts of the case before I comment on that. Because as a lawyer, I want to know the facts before I comment. But the present law is, if there is a will, it will go, for the Hindus, it will go as per the will. If there is no will, your spouse and kids get equal share of the property. Whether daughters are married, unmarried, irrespective of that.
I'll just add one thing if you don't mind. I'm not an expert, but for whatever reasons I've been involved, and Ketan, what you said is very correct. I've seen a few examples like this where the daughter has actually challenged, even getting, let's say, 1/3, she's demanded around 50%. And what our learned speaker was mentioning about movable assets, I've seen a case going to court, everything was divided, everything was accepted. The division problem was on shawls. A collection of Jamawar shawls and two shawls, which were running into a couple of crores, became the bone of dispute.
And that does happen. Okay, so, yeah.
So bringing you back to that US citizen, the father gifts a flat to a US citizen son. What will be the tax liability for him?
I'm not a tax expert of the US laws. I only know the inheritance part of it, which I've explained to you. I would advise you to consult a tax advisor. Okay, the advantage, I mean, we discussed most of the advantages, but I just explained it. It avoids disputes with the family, disputes, that says according to your wish, helps make provision for minor children, disinherit certain relatives who you don't want to give your properties to, and you can choose your executor. Disadvantages next thing. Okay, I think I already covered this. You just get a medical certificate, do independent witnesses, and go to a expert to make a law. So it's and get it registered. These are 3-4 more things. I've already discussed it. Can be challenged by anybody in court. No only controls assets that in one state. Not helpful when one becomes medically incapacitated. Next slide. Okay, this is technically not written, but I think I've mentioned this. There's a concept called living will. Okay, and people a lot of time ask me these questions. I just thought I'd briefly take 2 minutes on this. A living will is when a person decides how he or she has to be medically treated in case he or she becomes medically incapacitated and not able to make a decision on her own. I mean, sometimes people don't want to be like vestigation on the bed. So they want the option, so-called euthanasia, or tell the doctors what to do, what not to do. It's a very grey area, but it's still coming into practice in India. And there are Supreme Court judgments of that, which have gone either way. So it's a very grey area, but if you get make a living will and get it attested by a magistrate, it can be accepted. Let's just switch. Go to the next thing. Okay. Now, obviously, you see the will, the biggest advantage of making a will is the cost. It's very less, negligible cost. Now, a trust. All the issues which is discussed about this intents going to US citizen or everything, the best way to avoid all that tax and or other issues which are talking about of the medical capacity is to form a trust, where you over a period of time transfer all your existing assets to the trust and acquire new properties if any, in the name of the trust. Okay? A trust is an agreement with the settlor, the creator of trust, and the trustees to monitor and look after properties for the benefit of the beneficiaries. So the beneficiaries will be your wife, your spouse, your kids, whoever you want it to be, or none of them at all, depending on who you are comfortable with and who you are not comfortable with. Okay, next. It helps in inheritance and tax planning, especially when kids are in different jurisdictions like the US or UK where there are tax issues. It helps for if within the family you have a disabled child or a disabled family member, so his or her life interest is protected. Ring fencing assets from disputes or from, okay, I'll just give one example. I mean, I trust some of you guys are from the business families who have various corporate entities. In case you're taking a loan in your corporate company's name and you go default, then even your personal assets can be attached by the bank. But however, if you transfer your personal assets to the trust, then the bank cannot touch those assets. For the simple reason, it's not in your individual name, it's the name of another entity where you don't have any control of. In fact, this has been tested very recently, about 4 or 5 years back. There was this, Patanjali had acquired this company run by the Saryas, the Ruchi Group, Ruchi Soya, which had gone into default. In fact, I was the lawyer for Ruchi Soya, and since in the media I'm discussing it, they had formed a family trust called the Shiva Foundation, and they had acquired a couple of immovable properties in that foundation, in that family trust. Those properties could not be touched by Patanjali Group when the acquisition happened to the NCLT because it was a different entity and it was a trust. So those assets are still secure with the Sara family, fortunately for them. So it has been tested by the NCLT and by the Supreme Court. So we know this test works and doesn't work. Primarily 2 different types of trust. People get confused between a charitable trust and a private trust. A charitable trust is one which earns you 10% trust, or even the Rotary trust is a charitable trust. So that's a public charitable trust. We are not talking about that trust. We are talking about private trust, which a family operated run for the benefit of the family and individual members. Next thing. There are three types of private trust: revocable, irrevocable, and discretionary revocable. The main thing is revocable is when the settler or the maker of trust can revoke it at any time. Irrevocable cannot be revoked at any time. And discretionary, the discretion is given as per trust to the trustees to manage the fund. So the ways corporation and population may be involved to fix all three to suit the requirement of the client and how to manage his or her property falls into time. Go ahead.
This will get time check, we'll have to close the next 2-3 minutes.
Yes, that's on that.
Come to your question.
How do you then remove your properties from the trust?
See,
You cannot-
a trust is like a private company or an LLP. So like how a private limited company or LLP sells or buys trust, same thing applies to the trust. The trust is managed by what we call the trustees, like the board of directors you have in the private company or a designated partner you have in the LLP. So since the trustees will be mostly family members, they can buy or sell depending on what the requirement is in the name of the trust. Okay, the limitation of the what's the disadvantage? One is the cost. If you're transferring, see, making a trust is not expensive, but when you're transferring immovable property or your flat, your offices to the trust, then the stamp duty valuation goes up to 6%. So that is a costly affair. But that is a minor cost to pay against paying 40% or 30% if your kids are abroad and inheriting that property and or for medical capacity in the region. Okay, so this is some example, pros and cons of will versus trust. See, by adopting a trust route, the trust property remains with the trust. You don't have to wait for 1 year after the will to get probated. The challenge of will is obviously avoided because everything is named on trust. So, it's pakka up and running at your lifetime, and you can modify the trust as and when you please to. Yeah, I think just last slide, just move this. Gifts. Gifts arises between two living people. It doesn't happen post or demise. So sometimes people start gifting their properties during their lifetime to their near and dear ones to avoid the concept of will and or trust, because the stamp duty on will on a gift for residential properties as low as 200 rupees. So the cost is not too huge amount. I am a very big cynic of adopting gift as a mode of estate planning. Reason being, once you transfer property to your next generation, I don't know how much the next gen will look after you and stay with you. Once you transfer your properties to the next generation, by a gift, if they control property, we're seeing disputes arising then also. Then the tendency not to look after the
But it
fund.
can be mentioned that we want to
Everything
gift
It
it after our
can
demise.
be conditional gift also. But there can be conditions attached to the gift also.
That's what I'm saying. Yeah.
That's possible, but we've had cases with the Sikharia family, the Raymond group, where everything was gifted in lifetime and you know what the issues are, I think. So the ways to manipulate everything. So yeah, we've asked questions, any further questions I have.
One question. What about gifting cash, shares, mutual funds during a lifetime?
That you can do, there's no cost to it.
There is no limit, no?
There's no limit. Only you have to be sure if you're gifted to non-family members, because then there'll be income tax applicable to them. Within the family, there's no issue.
May I request all of the questions could be taken after 7:30, because in the interest of time we have the very important session called You Are Fired with.
Plan for our club after here.
That's leadership succession, not
Don't
state
ever
succession.
I mean, right.
For that we have different experts.
We form a trust for them with you.
Thank you so much, Apurva. It's been a pleasure. I think it was a very good session. So thank you for coming down and about recording band kar diye. Thank you very much. Sorry, you should yes, you
Let's get on. We always do it first.
You're fired! You're fired!
I'm fired, मैं जा रहा हूँ.
Why didn't you?
about the
Give the
president
topics
since that
first.
this is to be done political members run it.
We will do it next time onwards.
Is there some more presentation?
No, it's done.
Of Ankit Tiwari?
He's waiting outside. I'm just calling him inside.
Yeah, call him in.
Yeah, I'm just calling him inside.
If you're from business families.
How long does it last? 2 weeks, 3 weeks, that's it. And they transfer the trust to a resident.
You have the cash flow to give that fund.
No, I'm asking generally. So what?
I can already see my questions.
There's a charge to transfer some asset.
You are doomed.
For your property as a venture,
You are doomed.
the stamp on 5%.
Telling you, you are
Oh, you have to pay stamp duty.
For inward property.
Can you gift it?
Same thing, stamp duty will be up to 5%.
Otherwise it will be much more.
That's it. I mean,
Let me call you. Yeah. Thank you so much.
For the problem that may occur, whether you register a probate, somebody can come and put their finger in anybody. Why would you still feel, apart from the fact that what you said that they may not look after you, whatever, why would you still feel that it would not be advisable to give it during the life of the person alive? Apart from the fact that you said that somebody may harass you, etc. Leave that part aside.
frankly, and you trust a kid to look after you after he's taken all your sets? Answer that question.
After what, sir?
After you gift all your sets to your kids, or wherever, do you expect the kids to look after you or respect you?
No, I'm saying presume I do.
You're very
Presume-
valid.
I don't presume anything. You have to answer that question.
Suppose I say that I feel that they would, then would it not be
They
advisable
would. If you think they would, because as a good way, 90% of the time I've seen after the
property or whatever come?
assets have been transferred to next generation, the respect, the love, and looking after the parents suddenly overnight changes. I've seen in my own personal experience. So that's why for me to do the transactions, I'm making more money.
You are?
In fact, if you come to me and say I want to gift, I'll charge you launch fees and do it, but I'll tell you not to do it.
So how would one just call you?
Call me anytime, come over.
No, because right now it's at least I don't know about India, but abroad I've seen there's a lot of tendency for people to give property, not property, I'm saying give things away while they're still there, so that at least they've got that person, and if I give something to him, and if you don't get something, presuming that we are all family, would I be wrong presuming that you can't do anything to him?
You can't.
That's what I thought.
I can't, but then that's what I'm saying. If you see a rift and you do something in your lifetime, that rift will increase furthermore. You may feel it will not, but it does. That's practical. Today between two sons, if you favor one son, the other son is obviously going to.
No, what I mean is suppose that there's equitable distribution, whether there's value or whether there's
Can I
property.
answer that question very honestly? No two people will think they've got an equal distribution of assets. If you find me two people who think that way, I'm happy to change my mind. Or give you whatever you want. Find me two people.
ट्रस्ट का प्रॉपर्टीज बेचा तो पैसा कैसा निकाल सकते हैं ट्रस्ट में?
Trust me, that will probably trust deed how you want to take all the money. So trust deed becomes a constitution of your family.
So make a constitution that
So
way.
that-
कितना पैसा निकाल
So
सकते
that सब कुछ everything you mentioned to the letter in the trust deed.
The balance he will tell you when you pay him his fees.
It's not that you can.
No, but okay, fine. I'll drop it. It's not now. I'm traveling this coming month, but
कुछ करते हैं.
relevant point only.
Okay dear.
But I don't believe, if you don't leave a will and all the children get, you can claim.
Will में मारामारी होता है.
सब जगह मारामारी होता है. You have to just devise the best plan and go by it.